Sarah Boone lied to the court in this document in extremely important ways that completely misrepresent reality. And I can prove it. Before I get into that, a massive shout out to Tanika's 2 cents for sharing these documents with me, and without her doing that, this would not be possible. My original plan was to get some of these documents in order so I could share them with you to give you a better understanding in order what happened. Maybe you've seen some before, maybe you haven't, but a catch up because Sarah Boone is making a lot of claims. And what I found is Sarah Boone lied about some really important things. And it literally begins right here. On September 19th, 2020, a case management conference was held to discuss petitioner not abiding by the court's final judgment. The court verbally instructed petitioner to resume alimony payments and comply with the parenting plan. My thought immediately was, okay, if there's some instruction, it's got to be recorded somewhere, I would hope. But if I go and I look, there were no conferences between 2018 and 2022. But wait, look at that 2022 date. 9/19/2022. 9/19/2022. Sarah Boone claims this happened 19/2020. Now, I will tell you, there is a minutes for this hearing that shows up on the docket. I do not have it. I have asked Tanika's 2 cents if she possibly has these minutes. So if I get them before the end of this video, I'll edit them in now. If not, make sure you check out Tanika's 2 cents' video. I'm sure if it disproves or proves what Sarah Boone is saying, she'll want to cover it. But there's actually more than this lie. Because literally, when we go down to the next date she gives of April 11th, 2022, she says respondent files a motion for contempt. So I wanted to go verify it because I didn't see it in the files I have, but I don't have all the files, right? Well, if I go and I look at 4/11/2022, there is no listing there for her contempt. But then I searched contempt, and it's at 4/11/2023. So what this means now is that this is actually off by a year. This is off by 2 years. She's putting things in orders that make her sound better. Because it looks like Brian submitted his petition for modification of final judgment in reaction to her motion to contempt when these are in reverse order. But if we go and look, you can actually see right here's Brian's motion. It's real. It's really in 2022. So Sarah is just lying to make herself look better. And this changes things. Because, for example, here, in 4/18/2023, which this date is accurate, the petitioner subsequently filed a motion for continuance in response to the petitioner's motion for contempt, arguing that the pending motion for modification constituted a change in circumstances under Rosenblum v. Rosenblum. The petitioner asserted the court could not enforce the respondent's existing alimony and parental rights while the modification motion remained unresolved, which is still, to this day, unresolved. And the court granted the motion. So let's take all of this and let me just put this in order so you understand the way I'm understanding it now. The first thing in the order of events that happens was the supplemental motion for modification. Okay? This is first. So the first thing that happens is Brian says, I need to change his judgment, and he has a change in circumstances. There's a big change in circumstances on Sarah's end. It needs to change. We then have whatever happened in this conference, which right now you would have to take Sarah's word because I don't have the minutes. But do we trust Sarah when she's got all these dates wrong and change them in a way that makes her sound better? I don't think so. And then after that, we had her motion for contempt. And then after her motion for contempt, the judge appears to agree that he doesn't have to pay during the time frame where the motion to change it is active. So if the judge agrees with that, and here's case law to back it up, then he's fine from this date onwards, which is before everything Sarah Boone is claiming. Interesting, right? Fascinating. She's just lying because time disproves her, I guess. Blows me away. Anyway, for the documents, the document part. Here we have that attempt for modification. All right. I have it for you. Let me move it here so it's a little better visually if I can. The former husband, Brian C. Boone, individually, by and through his undersigned attorney, hereby files his petition for modification of final judgment. And let's just see exactly what he wants here. On February 25th, 2020, the former wife was arrested and charged with second-degree murder of her boyfriend after she locked him in a suitcase. The former wife was committed to custody of the sheriff of Orange County and has been held without bail in the Orange County jail since February 25, 2020. The parties have one minor child, born 2010. The minor child has lived exclusively with the former husband since the former wife's incarceration and lived the vast majority of the time with the former husband since the party's separation in September 11, 2017. Inasmuch as the former wife is in jail, she does not have the financial need for alimony or child support payments at this time. The former husband has voluntarily deposited money into the former wife's inmate account so she may purchase items from the inmate commissary. Due to the former wife's lack of proper judgment, as described above, and because of her own behaviors in front of the minor child prior to her incarceration, it is in the minor child's best interest for the former husband to be awarded sole parental responsibility, decision-making, 100% time-sharing. The former wife does not have the mental or physical ability to co-parent at this time, nor can she exercise any time-sharing. Termination of alimony. Paragraph 4 of the final judgment requires the former husband to pay durational alimony to the former wife in the sum of $1,000 per month in a period of 84 months. The former wife does not have the financial need for alimony at this time and will not through the period of the durational alimony, which, if not earlier terminated or modified, would end with the payment due April 1st, 2025. Also, due to the former wife's admitted egregious behavior of locking her live-in boyfriend in a suitcase, which ultimately led to his death, she is not entitled to alimony. The termination of diurnal alimony shall be retroactive to February 25th, 2020, the day of the former wife's arrest and incarceration. And the alternative, the former husband requests that the alimony be reduced or at least suspended for the period of time the former wife is incarcerated. Termination of child support. And this is basically that since February 25th, 2020, the former child has lived exclusively with the former husband, who is responsible for 100% of his financial needs. The former wife does not incur any expenses for the minor child, as she is not entitled to child support. Termination of the child support should be retroactive, and there's attorney's fees. Former husband attempted to come to a resolution of these issues with former wife, without the necessary of filing a contested supplemental petition for modification, requested that the undersigned attorney prepare a joint stipulation. Former wife would not sign the joint stipulation, which resulted in the filing of this action. The former wife should bear the responsibility for the former husband's attorney's fees, as her actions and her failure to act necessitated the attorney's fees. And basically, he just wants child support to end, alimony to end, and make her pay the fees. Now, this was... let's get this up here. 4/12/2022. 4/12/2022. This is 10/17/2022. We don't owe you anything and are waiting for you to be guilt, so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud the phone is distorting. So loud, former husband, his father, came in and told him to stop being mean to me before hanging up. Honorable Dean, this is what was told to me by my 11-year-old son when I asked about his best friend and how she was doing since he hadn't mentioned her in a while. He told me she started acting strange after he told her he was moving and wouldn't see her anymore. She's upset with him. The conversation continued with me asking why he's telling his friends this, as nothing is set in stone and will be discussed when the time comes. Oh, we're leaving and it doesn't matter what you say, we have an attorney. Eventually, it turned into the aforementioned statement, and I was laughed at, disrespected, shut down, and hung up on by my son over asking about his friend. See, this is what I was trying to kind of get at in my last video, where people are like, well, if the son has to visit her or talk to her, the father can't, the son has to. What is Brian supposed to do if the son feels this way about her? Is he supposed to lock him in a suitcase and make him finish the call? What is Brian supposed to do when the son doesn't want to speak with her? Truly, there's nothing you can do at a certain point. That was the point I wanted to get last time. Like, this situation, if the son just hung up on her, which he did, what can they do? The son is old enough, obviously by this point, to make the physical effort to not speak to her. You see, this is where I turn and ask, how is this okay, Your Honor? This is exactly how former husband treats me and has unfortunately successfully passed this disgusting trait onto our son. I'm going to actually guess that no. I'm going to guess no. I'm going to guess that Brian didn't pass this onto the son. I'm going to guess reality did. I'm going to guess that the son fully knows what Sarah Boone did. I'm going to guess the kids at school fully know what Sarah Boone did. I'm going to guess that the son went and watched her interviews because he has access to the internet and came up with his own decision. Kind of like how the jury saw the evidence. Nonetheless, how dare both of them disregard me the way they're making me feel like I am nothing, no one, worthless, and a joke. I am sick of being laughed at. I took it upon myself not to call back and waited until the next day to talk about with former husband. Calmly and rationally, I asked him why our son spoke to me the way he did. Where is he getting the idea that you are definitely moving? He's losing good friends over it. Well, that's the plan, and I figure you should start getting used to it. 50 miles can be overruled. It means nothing. Laughing. That's why I have an attorney. You don't. We're just waiting for you to be sentenced. The judge knows everything, and there's not much you can do or say about any of it. You'll see. We're leaving no matter what, regardless of the outcome. What's the point of me fighting for my life with my son when I'm treated the way I am by both of them? This is a form of mental and emotional abuse. Former husband encourages and enables it. I'm yelled at for everything. I'm afraid to call for fear that I will be obliterated and brought to a new level of low, or try to see how I can be made to cry and then laughed at. I'm damned if I do, damned if I don't. If I do continue in my fight, which I will and am, I'm disrespected and almost destroyed. If I don't, then I look like the uncaring, heartless, incompetent mother person former husband is hell-bent on making me out to be. Wait. Does she say former husband because she's salty over him changing his motion to change and that... Hold up. I have to go back. Yeah. I guarantee she saw former husband here and stuck to it like she stuck to protocol. See, where was I at? There it is. I just started speaking to my son from being screamed at with cruel lies and horrible mean things that I will not repeat over nothing. I didn't call for 3 weeks because of the shock and pure hurt I am still in. I've definitely covered this on my channel before, I think. But I think I said this last time too. You can't say I never gave up, but also I gave up for 3 weeks. I am still in, was said, I am made to feel like a chore, burden, a pest. I am not welcomed. Like life is better without me. Everything is one-sided. My son never met my parents, grandparents, aunt or uncles, deceased. Never knew my family. He only knows the Boones who viciously slander me. His mom behind my back have perpetually made me the dumb black sheep and continuously plot my demise together. They poisoned my son and pitted him against me. Since day one, when I was just 9 days into my incarceration, former husband took it upon himself to make the egregious decision to tell him that I will be gone and he wouldn't see me for 25 years or longer of his little life. My son cannot be my son and is tortured by the confusion in whether he can be close to me, like we've always been, or even be nice to me. I feel, to be honest, our son is just an innocent pawn in former husband's scheme to seek his sad, bitter, unrelenting revenge against me. His something is broken plastic covered in fool's gold. That is really too close to her, like, statement in court, like at the sentencing. He is not the angel he appears to be. He is an insensitive, callous tyrant and fully endorsed by his family. No one listens to me. I have made the active decision to not call for an undetermined length of time so I can take a break from the beratement. You just said you never gave up. I can only take the terrors inflicted by former husband in doses. Right now, I've got my fill for both of them. If my son wants to speak to me, he can write or schedule a visit, which I doubt will happen from the lack of encouragement and inclusion of me to have a relationship with my son by former husband. Please understand, I can only take so much on top of everything else. I love my son. I need my son. Just not this version. Not right now. What can I do? What can you do, please? This is not right. Every time I speak to former husband about anything, ends up ugly, unsuccessful. He has taken it upon himself to self-diagnose my case from watching YouTube, his reliable source. Of course, Court TV, telling me my trial is less than 3 weeks away, assumes I fired all my attorneys. Remember, I am on the 6th, not by choice, and constantly tells me how wrong I'm doing everything. He keeps asking me why I keep delaying everything. He gives assumed case details about my witnesses, occurrences, etc. over the phone, telling me about my case. He is assuming everything. Well, to be honest, we now know that she's filing things from Tanika's 2 Cents channel, so I guess YouTubers are a great source for her case. He thinks he knows everything about my case. This is wrong. I'm being penalized even more for wrong, empty accusations and informations. This only multiplies his anger and spitefulness towards me, thinking my strategy is to do everything I can to keep him here. Ludicrous. This is why I felt the need, Judge, hesitantly include you in the ongoing struggles I'm having with former husband, and his incompetency regarding my life and case. It's never ending and only gets worse. I would also like it to be known I have not gotten any of my orders for a hygiene kit, deodorant that works, toothpaste, and a washcloth for a measly coffee package that I began asking for in July after you approved on September 13th? During our meeting, my ability to start receiving alimony again after former husband immensely diminished and tried to stay. Okay. So she's referencing again that the judge told her she could get alimony. But my question is, theoretically, let's say she's right. If theoretically the judge ordered it and he didn't do it, and then the next judge orders he doesn't have to do it since he filed because of the case law, what happens in that scenario? I don't know the answer to that. But again, did Sarah understand what was happening? There's always an excuse. The most recent and last 3 months is his debt credit card won't work because it's a jail and people steal. He's had to use our son's allowance card just to finally get me a hot meal. I mentioned to you, which ended up coming on my birthday, 10/10 only, because I told him this letter I'm writing. I'm still waiting on the other orders so I can be alert and presentable when my attorney does finally show up, who has not since the last time I spoke to you. Please know also my bank account, which I've had for 30 years, has closed due to former husband's failure to pay alimony as instructed in our dissolution of marriage agreement, then also by you. I cannot deposit any checks. One I've been waiting on for mail to make since February and could use towards commissary when he isn't giving me anything. All my subscriptions are not being renewed. Anything with autopay cannot approved. I cannot deposit the alimony former husband is supposed to be paying. I've had this account for 30 years. He assumed his plan would work in it not having to pay, so he withheld causing this to happen. I have no bank account, Your Honor. Also, for all the difficulties he's supposedly encountering with his credit card could have been avoided, would he have been paying and abiding by the rules, my bank account would still be open still, and he could have used my debit CC. I already have the necessities. I'm needing former husband and his own troublemaker. He makes his life more difficult from all his assumptions and defiant attitude. Even if I wasn't incarcerated, I'd be getting the same problems from him. He keeps tripping over power trips and taking it out on me. Where are my orders? How can I get my bank account reopened? He gets no relief from his own doing. Everything was okay before he tried implementing all his agreements and started his second job soothsaying. The constant assault of degrading remarks. Let me check here. Okay, we are near the end. Fear, infliction, and terrorizing threats must stop. It makes no difference how soft my approach is in trying to explain the former husband, how unnecessary and harmful his actions and comments are. And being the example he is to our son, giving permission, he can do the same, especially to me, his mother, and also to other women futuristically. Just stop, please. Former husband tries to taunt me every opportunity he can and get a reaction from me, knowing he's got the upper hand in almost everything and can either laugh at me, hang up, or both. As said before, I am not helpless. I have God and your awareness of my situation's judge, Dean, to hopefully impose your authority on all manner available to provide any permissible relief for everyone. Something needs to be done sooner than later, considering my trial has an unknown date. I refuse to continue cooperating with former husband on any of his terms, and the way they are being handled look at the bigger picture. In conclusion, the most painful, horrific remark made to me by former husband so far during my attempted call to talk about our son's upcoming birthday, 1028, with the conversation always turning into their exciting upcoming move, told me, when you're finally put away, this move will be the best thing to happen to us. Him, son. We can't wait to get out of Orlando and away from you. Laughing. Also, where we're moving is very close to the prison. It's going to be very easy and convenient for us. Thank you for your time and assistance, most of all your understanding. Waiting as long as I could and everything to involve you, but I don't know what to do or how much more abuse I could endure. I felt you should be included on what's happening behind the scenes when former husband and WC attorney aren't sitting in front of you in the courtroom, or you're reading one of their many scheming documents plotting what can you do to me next. You and God, thank you either way and always. Sincerely, Sarah Boone. While the motion for contempt was written for 7/2023, filed 4/11. So this is the motion of contempt Sarah Boone was talking about. Comes now Sarah Boone. Respondent submits her motion for contempt for non-payment of alimony by Brian Boone, petitioner, in which court ordered the Judge Michael Dean to continue being paid to respondent in the last and only status hearing 9/19/2022. Crazy she knew the correct date at this point. Since during and prior to the respondent's incarceration, 2/20 to present, petitioner has completely withheld or minimized incredibly thin We'll zoom in again. Incredibly the promised, forgot the E, or it's cut off, $1,000 monthly payment, saying repeatedly the respondent is not important and not priority. This money owes the respondent is overdue, ordered, and needed, being the only source of income to make any and all necessary purchases. Also, petitioner agreed to sign and made responsible for all said payments in the active court filed dissolution of marriage 2017. Respondent seeking all delinquent heirs payments and all full current payments of $1,000 going forward were to be made to the designated account of her choice. Wherefore, Sarah Boone, respondent, respectfully requests this honorable court to please grant this motion for contempt, entering its order for alimony payments delinquent in arrears to begin immediately and without difficulty or confusion by Brian C. Boone. Thank you, Sarah Boone. So, This is 4/20/2023. So this is after the judge agreed to the continuance from Brian's lawyer that cites the case law that he doesn't have to keep paying. If I have this right. Hello, and thank you for granting a hearing for my motion for contempt scheduled via Zoom 5/11/2023, 9 a.m. I am in the process of gathering my necessary evidence as requested, but want to remind you I am incarcerated and do not have the capability of using a computer to gather statements, calling about, or going to my bank. Even if I did, due to non-payment of ordered alimony, my former husband, my bank account, which I have had for 30 years, is closed from having an ongoing, growing negative balance for an extended period of time. Please know I'm doing all I possibly can from jail with what I am able to submit. I'm confident will suffice, showing not even one agreed, ordered, signed, or $1,000 payment, along with all decreased amounts chosen by former husband to give sometimes, and the everyday payments, deductions from my account. Please note, in the meantime, would alimony have been paid, I would not have to contact or be degraded by former husband every week to ask. I mean, you're supposed to be trying to contact your son, right? So you would be dealing with him. He knows when commissary day is and has for over 3 years. I've been here. My bank account would not be closed 30 years. I would have essentials and needed items. I would not be constantly lied to about phantom orders and made to ask for updates weekly. I would have peace of mind about being able to maintain blood sugar glucose levels from being available and needed snacks. Those honey buns are required. I would not have a negative balance. Other participants could purchase care packages for me without having to add money, so in the positive of my account, the only way to order. My medications could be paid for when processed. Again, shouldn't that be covered? My temporary life of incarceration could be, to a small degree, simplified. Former husband would not have to deal with me continuously. I would not have been keep contacting the court to take up the judge's time to order again former husband to continue paying. Former husband should not have made the decision to disregard the order and pay and made up his own rules. This way, this is contempt. It was never acceptable for my former husband to treat me in the very unacceptable way he is. I would not be incarcerated. I would not be incarcerated, which makes no difference and is temporary or is stated otherwise agreed to in the dissolution of marriage agreement. Former husband would have his license suspended, wages garnished, or be arrested and put in jail, where he'd have the idea real quick how it really works and could understand everything I've been trying to explain to everyone for years now. So basically, in the newest document, she wants him put into therapy to be told how he's mistreated Sarah, and she wants him incarcerated, like she did to George. We saw how that went. With that being said, my main and most important reason for this letter is a request to please a copy of my marriage dissolution agreement to properly prepare for this hearing. I refuse to be blindsided as I was for the last petition to relocate. I've asked former husband many times, as well as you, Judge Dean, verbally and even in writing, with no success. Document is a must for this hearing, and only fair that I have also. Please send at your earliest convenience. Refer to me when I can obtain immediately. I've been asking for this for over 3 years. I want some advantage in having this document and what the entire hearing is about. Thank you for the opportunity. Sarah Boone. Just real quick, while Sarah Boone claims she couldn't get a lawyer to work on this, she did. Frank Bankowitz was helping, and like a lot of her lawyers, he wanted out of there on this too. This is March 5th, 2024. This might be the order where Sarah Boone claims she was told it was irrelevant that she wanted those text messages and things, but let's just read it here. The cause having come before this court on respondent's motion for court order to obtain, preserve evidence for pro se respondent hereafter motion, the court having reviewed the motion and court file hereby finds and orders as follows. The motion lacks a specific legal basis for the relief requested. As per Florida Family Rule of Procedure 12.100b, a motion must state with particularly the grounds upon which it is based and clearly set forth the relief order sought. Respondent only cites 12.200, which is not a legal basis for the relief requested. Consequently, in accordance with Florida Family Rule Procedure 12.100b, the motion is hereby denied. Not entirely sure what this is about, but it's in the files I have, and it's in order, and this is from 2024. So this is kind of where I'm going to end this off, just kind of give you an order of what Sarah was doing. But wow, she lied. Like, it drastically changes things when you look at the actual order of events. Because if I'm understanding this right, from the moment he filed, that he needed a change in circumstance, he's arguing that the case law says that's the date he doesn't have to pay anymore. And it looks like the case law backs that up, from what I can tell. And Sarah is just ignoring it. Not just ignoring it, in her latest filing, changing the dates of things that happened in court to try to make herself look better? Absolutely wild. It's wild that she's doing this, because the judge can just look. If I can look, the judge can look.